Hello, everyone. Welcome to Season 1, Episode 5 of ARBinBRIEF, a practical video guide on hand-picked arbitration issues. My name is Ibukunoluwa Owa, and I'm a member of the ARBinBRIEF team. ARBinBRIEF videos offer a quick resource to consult on issues that arise in international arbitration, while showcasing talented arbitrators in an interview format. Over the course of 10 episodes in the first season, we'll move through the life cycle of an arbitration. Today, we'll be focusing on hearings, in particular, conducting virtual hearings as a sole arbitrator. For those of you joining us live, the 15-minute interview will be followed by a 15-minute Q&A. Please send any questions through via the question and answer function. And then during the question and answer function, anyone who wants will be invited to turn their cameras on, and we encourage you to actively participate. I'm now honored to introduce our arbitrators today. Our first arbitrator is Luminita Popa, who will be conducting the interview. Luminita is a founder and managing partner at Sole Popa, a Romanian full-service law firm with a strong international dispute resolution practice, and has been recognized as a GAR 100 leading arbitration practice. She regularly serves as an arbitrator and is recognized as a leading practitioner by Legal 500, Chambers and Partners, IFLR 1000, and Who's Who Legal. Our second arbitrator today is Apostolova, who will be interviewed by Luminita. Kate is a senior associate at Freshfields, Singapore. She's ranked #1 in Asia Pacific by Who's Who Legal 2020 and named 2021 Rising Star by Lloyd 360. Kate has extensive experience representing clients in a wide range of industries, including the oil and gas industry, mining industry, nuclear power, construction, finance, and technology industries. Over to you, Luminita and Kate.
Thank you. Good morning, Kate. It's such a pleasure to talk to you today. The topic of our discussion today, conducting virtual hearings as sole arbitrator, is definitely not an exclusive creation of the COVID-19 context. However, it is fair to say that its importance and relevance were significantly enhanced during the past 2 years. I'm confident saying that all players in the international arbitration field came across issues related to the legal framework for conducting hearings remotely, or to the tribunal's power to order a virtual hearing, or on how to organize it as to preserve all features of an in-person hearing. And very diverse experiences have been shared up to this moment. So, Kate, what was your experience, and do you think that the remote hearing is the new normal or just a trend, a necessity today?
With the COVID-19 pandemic in the last couple of years, I think virtual hearings have become the new normal, and I think they're here to stay. I don't think physical hearings will be replaced, but we are likely to see more virtual hearings even after the pandemic. So far, my personal experience with virtual hearing has been very good. The quality of the virtual hearings I have had has been the same as physical hearings. So as an arbitrator, overall, I gained the same understanding of the facts of the case. I had the same understanding of the legal issues. I asked just as many questions. And I thought that each stage of the hearing worked just as well virtually as in person. So, for example, the opening statements were just as effective with the use of PowerPoint slides with counsel shared on the screen. Witness and expert testimony was also well received. And I think this has been my experience in large part because I had the right setup at home with 3 big screens, which allowed me to see the witnesses and experts just as well as in physical hearings. As you know, it's often said that an arbitrator is unable to assess the credibility of a remote witness or expert because of the loss of the non-verbal cues. But that has not been my experience in the particular cases I have had so far. And in fact, because I had the right setup at home, I think I was able to see the witnesses and their facial expressions on the screen better than I might have at a physical hearing. I could zoom in if I needed to and watch them carefully. So overall, I have been satisfied with my virtual hearing experience so far. And I think virtual hearings can work just as well as physical hearings in the right cases.
Well, that's very encouraging to hear that you had a satisfying experience. And from my experience, usually a satisfying experience with a virtual hearing is fundamentally based on a very good planning and a detailed organization. There's something that I'm curious on how you see it. Do you think it is easier or more difficult to conduct a remote hearing as a sole arbitrator?
I think in a sense, it is more difficult to conduct a virtual hearing as a sole arbitrator because it all falls on you. So first, the decision itself, whether to have a virtual hearing or not, is on you. And in a situation where one party insists on a physical hearing while the other insists on a virtual hearing, and depending on the specific circumstances, this decision may be a difficult one. As the sole arbitrator, you alone have to decide by balancing the party's right to be heard and treated equally with your own obligation to conduct the arbitration in an efficient and expeditious manner. Second, the preparation for the virtual hearing has to be done all by you. As you said, Luminita, a good experience with a virtual hearing is fundamentally based on good planning. And all that planning is on you as the sole arbitrator. I have had very good experience with virtual hearings, but I think that is mainly because I did a lot of planning ahead of time to make sure that there will be no technical problems. So, for example, in an arbitration last year where I was the sole arbitrator, I had several prep calls with counsel, the witnesses, and experts just to make sure the technology was working properly for everyone. I also planned for 2 backup options in terms of the platform we were going to use for the virtual hearing. So we planned to use Zoom, and we tested the Zoom connection with all who were to present and testify at the hearing. If Zoom didn't work, we also tested a Microsoft Teams connection. If both didn't work, we also tested a Skype connection. So really planning is key, and it's on you as the sole arbitrator. And finally, during the virtual hearing, you're the one who has to ensure that it is conducted properly. So it's on you to make sure that the witness being examined is really alone in the room, that the documents in front of the witness don't have any notes, that they're not receiving any external assistance during the examination. And you have to be careful and pay very close attention to those issues throughout the hearing. So I think in a sense, it is more difficult to conduct a virtual hearing as a sole arbitrator.
And let me ask you this, what about the particularities of a case? Do they matter? Do you think that there is a threshold of materiality or of complexity of the case which would be relevant for how hearing is to be held remotely or in person?
I think a virtual hearing is likely to be appropriate if both parties agree. So the parties would know if their case can be heard virtually. Otherwise, if there's a disagreement between the parties, I think it'll depend on the particular case. So if what makes a case complex is the legal arguments, I think an arbitrator can have the same understanding of the legal issues in virtual hearings as in physical hearings. If there are concerns that the witness or an expert might be coached during the testimony, arguably there are technical solutions for that. There are specific applications for a 360 view of the room where the testifying person is. You can also arrange for a representative from the cross-examining party to sit with the witness to ensure there's no outside influence. Or in some of those cases, having a hybrid hearing may be considered, where the witness you're concerned about is heard in person. If what makes a case complex is the factual matrix, having a lot of documents on the record, needing testimony from a lot of witnesses and experts, a remote hearing is likely to be more difficult, and there are more issues to be considered in that scenario, I think. But it's not only high-stake cases or big cases that pose challenges with virtual hearings. Any case can pose a challenge. For example, I had a case last year where one of the witnesses was located in a remote area with no stable internet connection and no computer facilities. So that witness couldn't participate in a virtual hearing from home. And I decided to postpone the hearing until we could all meet in person. and at the same time come up with a backup plan to ensure that the witness in question had access to the minimum equipment and the minimum connection required if we were eventually unable to meet in person. So ultimately, I think it's correct to say that whether a virtual hearing is appropriate depends on the particular case.
One very interesting aspect that you have also mentioned, and I would like to ask you further on this, is the situation when one party does not agree with holding the virtual hearing, because one particularly important discussion regards the tribunal's power to decide on remote hearings, and the analysis is not complicated when the procedural rules are very clear or when the parties are in agreement. But what happens when a party wishes to have a virtual hearing and the other party doesn't? Did you experience this type of situation as a sole arbitrator, and what was your approach?
I was in a situation last year as a sole arbitrator in an international arbitration where one party objected to having a virtual hearing. So we had scheduled an in-person hearing in Singapore in the first quarter of the year. But right before the scheduled hearing, Singapore and the country of the claimant went into a lockdown. And I asked the parties if they wanted a virtual hearing, but the respondent insisted on an in-person hearing. And so I had to assess the situation and decide whether to hold a virtual hearing or delay the proceedings. And I took into account a number of factors, including the reason for the virtual hearing. It was obviously the pandemic when traveling was not allowed, so this was not a small inconvenience. The content of the hearing, so we had several witnesses and experts that were going to testify at the hearing, whether there will be any technical difficulties if we had a virtual hearing, and then as the potential delay. So ultimately, I decided we will wait until the lockdown ended, which was supposed to last for about a month. I was in constant touch with the parties, evaluating the situation every time the lockdown was extended. And after about a 2-month delay, I asked the parties to consider again if we should have a virtual hearing. And at that point, both parties agreed, and we did schedule a virtual hearing eventually.
So in your case, ultimately the parties did reach an agreement for a virtual hearing, but many times they do not. And it is for the tribunal to make this decision, which renders extremely important any support in the procedural rules. That's why during the past 2 years, many arbitral institutions have introduced express provisions in their rules. This is the case for the ICC, for example. And another example is the Delos rules, Article 12.4 from Delos rules. And in an incomplete quote, it says the tribunal's power shall include, but are not limited to, the following: to render an award with or without holding an oral hearing or meeting, and to conduct the same remotely in hybrid format or at a location other than the seat of arbitration. How do you understand this update from 2021 in Delos rules, and how important do you think it is?
I think this is a very helpful update. I agree with you that when the parties don't agree on having a virtual hearing, it's important that the applicable rules expressly provide the tribunal with authority to decide whether to hold a hearing remotely or not. So when it's explicit in the rules, like it is in the Delos rules, that gives arbitrators the express authority and the comfort that they can decide to hold a virtual hearing over the objection of one of the parties. So it is a very helpful update, I think.
And now the last question. Let me wrap up our session and leave some food for thought for our audience with this question. What do you see as the greatest advantage of a virtual hearing on one hand, and what would you see as particularly important to pay attention when holding a virtual hearing?
So I think from the parties' perspective, the greatest advantages of a virtual hearing are saving time and costs. International arbitration is criticized as being too long and costly. Holding a physical hearing often means having a longer time frame because you need to find a block of time that works for the arbitrator, for all the parties, client representatives, witnesses, experts, and someone has to fly to a different place. And virtual hearings are often easier to schedule given they don't involve traveling, so the time frame for the arbitration is likely to be shorter. Saving on costs is another advantage to the parties. Costs of a physical hearing are generally a lot higher than costs for a virtual hearing and include expenses for the physical venue, airfares, and hotels. And those are expenses you usually don't have in virtual hearings. Of course, that's not to say that there are no expenses for virtual hearings, especially if you have top-end platforms and possibly have to rent and mail monitors or iPads. But generally, the expenses are less than costs for physical hearings. From the arbitrator's perspective, I think virtual hearings help with avoiding jet lag and with being more fresh during the hearing. And you can, of course, do more hearings since the virtual hearings, you save time on traveling. And finally, from everyone's perspective, it's just better for the environment, given in virtual hearings, you don't get on as many flights, and they're usually soft copies of the hearing bundles, not hard copies, which means lower carbon footprint, which is in line with the campaign for greener arbitration and making international arbitration more environmentally friendly. In relation to the second part of your question on the specific points of attention when conducting a virtual hearing, I think an important step is setting out the rules for the conduct of the virtual hearing. So as the sole arbitrator last year, I first discussed the rules for the conduct of the virtual hearing with the parties, and then I issued a pre-hearing procedural order setting them out. So the pre-hearing procedural order provided for when the parties' representatives and the tribunal should join the video link for the hearing, which was 15 minutes prior to the scheduled start of the hearing to make sure the connection worked well. It also provided for when the party should ask respective witnesses to dial into the video conference, which was only when they were called to testify. All participants had to keep their microphones muted unless speaking, and except for me as the arbitrator. I also had the ability to mute and unmute microphones. We also agreed on what happens if any party disconnected unexpectedly. So I think it's important for the efficient conduct of a virtual hearing to agree certain rules ahead of time so everyone knows what to do and the virtual hearing goes smoothly.
Thank you so much, Kate. I think this was extremely useful. Thank you.
Welcome. Thank you.
Thank you very much, Luminita and Kate, for this incredibly insightful and also timely discussion, considering the times that we're in now. We would also like to thank our partner organization, Delos, Mundi, and ARBinBRIEF for their invaluable support, and to our other supporting organizations. Delos Dispute Resolution is an independent arbitral institution established in 2014, and Mundi provides arbitration resource tools for lawyers, including a directory of more than 5,000 profiles with arbitrator analytics. Arbitrators today, Luminita and Kate, are also featured on this. And the ARBinBRIEF establishes concrete and actionable steps to increase the number of women appointed arbitrators.